Hi, my name is Derek Willingham, a labor relations specialist with the Field Services and Education Department at AFGE. In this training video, we will discuss mandatory, permissive, and prohibited subjects of bargaining. All possible bargaining subjects fall into one of these three categories. First, there are mandatory subjects of bargaining. These are subject matters over which the parties have a legal obligation to bargain. If the parties cannot come to an agreement while negotiating a mandatory subject, we can submit the issue to Federal Service Impasse Panel called FSIP. At FSIP, we present our case for the proposals, and after hearing the case, FSIP decides what contract language will be in the contract. Second, there are permissive subjects of bargaining. These are subject matters over which the parties do not have a legal obligation to bargain. If the parties cannot come to an agreement while negotiating a mandatory subject, we will not be allowed to submit the issue to FSIP. Finally, there are prohibited subjects of bargaining. There are a number of topics which the parties are prohibited by law from bargaining over. Let's examine these types of bargaining. Mandatory subjects of bargaining are subjects relating to terms and conditions of employment over which the parties must bargain over in good faith if a proposal is furnished. Because it is a matter over which the parties must bargain, it is illegal for the agency to make a change to a term and condition of employment which is a mandatory subject of bargaining without first bargaining it to completion. It is illegal for the agency to fail to bargain a term and condition of employment which is a mandatory subject of bargaining without demonstrating good faith. Good faith means making a serious effort to bargain honestly, sincerely, and with the goal and necessary commitment to reach an agreement. When we say terms and conditions of employment, we mean all personnel, policies, practices, and matters affecting working conditions, except matters relating to political activities, classification of any position, or issues specifically spelled out in federal law. That is a very broad definition. In order to determine if something is a term and condition of employment, the Federal Labor Relations Authority, who oversees federal labor law, applies a simple test. The FLRA considers two factors in determining if a proposal involves a condition of employment. One, whether the matter proposed to be bargained pertains to bargaining unit employees. And two, the nature and extent of the effect of the matter proposed to be bargained on the working conditions of those employees. In review, mandatory subjects of bargaining are subjects relating to terms and conditions of employment that, upon request, a party must bargain over. If a proposal is within the mandatory scope of bargaining, management cannot legally refuse to bargain over it, and the Federal Service Impasse Panel can impose it on the parties. With the permissive subject of bargaining, the parties are permitted to bargain over matters although they are not required to do so. A permissive subject of bargaining, sometimes referred to as B1 bargaining because it is laid out in the 5 U.S.C. 7106, B1 is a subject that the agency may bargain over but is not required to do so under law. Because it is not a subject matter of which the parties must bargain, either party may refuse to or stop bargaining over a permissive subject. Permissive subjects of bargaining include the numbers, types, and grades of employees or positions assigned to any organizational subdivision, work project, or tour of duty, or the technology methods and means of performing work. The agency can stop bargaining over a permissive topic at any time prior to reaching a final agreement. It is not an unfair labor practice to stop bargaining over a permissive topic. Parties cannot submit a proposal over a permissive subject of bargaining for impasse. Once in the agreement, a provision of any permissive subject is just as enforceable during the life of the agreement as any provision on a mandatory subject. Once an agreement expires, mandatory subjects remain in effect and permissive subjects may expire, unless you negotiate specific terms saying that permissive subjects will continue upon expiration. Finally, there are prohibited subjects of bargaining. These are subjects over which we may not bargain. These prohibited subjects have three main types. First, we cannot bargain over proposals set by law, such as pay, health insurance, and retirement. Second, we can't bargain over proposals which conflict with government-wide regulations that are in effect at the time of negotiations. This broad prohibition of proposals, contrary to government-wide prohibitions, is different from the third prohibited type of proposal, which conflicts with agency-wide regulations. The third and final type of prohibited bargaining proposals is one which is contrary to regulations at the agency or primary national subdivisions, where the FLRA determines that there is a compelling need for the regulation. Compelling need is when the rule or regulation is found to be essential to the accomplishment of the mission or the execution of the function of the agency. Proposals cannot be contrary to any rule or regulation that is necessary to ensure the maintenance of the basic merit principles. That is a high bar for the agency to clear. Although we cannot bargain over pay, insurance, and retirement, the law leaves lots of terms and conditions incomplete, providing for details and options that can be bargained. We can still bargain for compensation increases, including but not limited to the criteria for career ladder promotions, the right to insist temporary promotions where there has been a change in duties, performance awards, transportation stipends, tuition reimbursements, prices for food services, and parking. You may be asking yourself, what about management's rights? That is the most common reason management will claim they don't have to bargain over a proposal. Why haven't you mentioned that yet? Because the management's rights exclusion is covered under the first type of prohibited bargaining, subjects established under law. Management's rights are prohibited bargaining subjects, and they are clearly spelled out under law. Under 5 U.S.C. 7106B, management's rights that cannot be negotiated away include determining the budget, organization, number of employees, internal security, and actions which may be necessary to carry out the agency's mission during emergencies. As you look at that list, you may be realizing that the scope of management's rights we cannot bargain over is much narrower than you might have thought before. And remember, not only is that list narrow, but we have a right to bargain over the impact and implementation of any management's change that has a significant effect upon the bargaining unit. Our bargaining rights are significant, and knowing when we can exercise them is the first step to getting the best contracts we can for our members and being big enough to win.